My stepmother handed me a copy of the will at my father's kitchen table and said, "I hope you understand." The will left the house, the savings, and the investment account entirely to Claudia. There was a paragraph near the end that referenced his daughter Nora with the specific language of a person who has been advised by someone that acknowledging the existence of a child creates fewer legal complications than omitting them entirely. And that paragraph said, "I leave my daughter Nora my personal effects and the sum of $3,000, and I hope she finds peace." $3,000. My father had been retired for 7 years and had spent his career as a civil engineer and had built, over that career, assets that I understood to be in the range of $400,000. He left me $3,000 and his personal effects and a hope that I would find peace. Claudia handed me the document with the expression of a woman delivering a verdict that she considers final. I said thank you. I drove home. I sat in my apartment in Cincinnati, and I thought about my father, and I thought about what I knew about Claudia and what I did not know, and I thought about the specific quality of the 2 years of their relationship that had produced a will that left me $3,000. The relationship had moved quickly. They had met at a church social and married 14 months later. My father had been widowed for 11 years when he met her. He had been a practical and methodical person who had, in other contexts, moved slowly and checked his work before committing to things. The speed of this had felt unusual at the time, and I had told myself that grief processes differently at different stages of life, and that I want to describe the 3 weeks between the will reading and the initial record search. I do not want to rush over them as if they were just a waiting period, because they were not. They were 3 weeks of being in the specific state that follows a major loss and a major injustice simultaneously, which is a state that is neither clean grief nor clean anger, but a combination of the two that occupies the mind and the body in different ways at different times, and that does not allow for the orderly processing of either. I went to work. I ate meals. I called friends when I had the energy for conversation and declined to call them when I did not. I thought about my father a great deal. I thought about the house in Milford and the oak trees and the maintenance log in the kitchen. I thought about the 14 years of entries in that log and about the last entry I had seen in it, which at that point I did not know contained the sentence about Nora and the long-term plans. I had not yet had access to the log. I was thinking about it as an object associated with my father rather than as evidence. At some point during those 3 weeks, I also thought about Ruth's comment. I kept coming back to it. An ex-husband had come looking for Claudia. The word ex-husband keeps appearing in this story for a reason. The reason is that Ruth used it, and it was the word that mattered. A man who described himself as Claudia's ex-husband was looking for her. If he was her ex-husband, there had been a marriage. If there had been a marriage, it had either ended legally or it had not. On the Sunday afternoon, 3 weeks after the will reading, I sat down to find out which one was true. I found out in about an hour. The records were there, and the absence was there, and both of them together said what they said, entitled to what made him happy. What made me start asking questions was not the will itself. It was a comment from my father's neighbor Ruth, who had known him for 20 years, who mentioned at the reception after the funeral that she had seen someone at the house recently who had introduced himself as Claudia's ex-husband and who seemed to be looking for her. Ruth said it with the slightly lowered voice of a person relaying something they suspect is relevant without being certain why. I thanked her, and I wrote down what she had said in the Notes app on my phone, because I have the habit of writing down things I think I might need later. The note said, "Ex-husband looking for Claudia." I did not know what to do with it immediately. I put it in the Notes app and I drove home. Before I go on, if this story connects with something real in your life, please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Nora. I am 33 years old. And this is the story of how a county clerk's marriage index, an online court record search, and a family law attorney named Patricia, who had been handling Ohio domestic cases for 19 years, gave me back what my father built and exposed a marriage that should never have been legally possible. Now let me take you back to the beginning, not the kitchen table with the will, before that. To the house in Milford, Ohio, where my father had lived for 14 years and where he had built, after my mother's death, the specific quiet life of a man who has processed a great loss and has arrived on the other side of it with a set of routines that give shape to the time available. My father's name was Leonard. He was 71 when he died. He had been a structural engineer for 38 years and had retired at 64 and had spent his retirement in the specific way of engineers who have had careers defined by problem solving, which is to say he continued to solve problems, he just chose different ones. He maintained his own house. He volunteered at a local historical society doing document preservation. He kept a garden. He was a methodical person who trusted process and whose trust in process had served him well for 7 decades. Claudia came into his life when he was 68. She was 53. She had grown up in southern Ohio and had come to the Cincinnati area after, she said, a difficult first marriage that had ended some years before. She was warm and capable and spoke about the past with the specific vagueness of someone who has decided that some chapters are closed and that opening them is unnecessary. My father seemed to find this vagueness natural rather than suspicious, perhaps because he was himself a person who had not discussed his own grief excessively and who had learned to respect the privacy of others around their pain. She moved into the house 8 months after they met and married in a small ceremony 6 months after that, 14 months from the church social where they had been introduced. I want to be honest about what my relationship with Claudia was like in those 2 years. It was not hostile. It was careful. I had the specific caution of a daughter watching a parent enter a new relationship after a long period of solitude and trying to be neither obstructive nor naive. I had dinner with them regularly. I was polite. I watched. I noticed that Claudia managed the social dynamics of their relationship in a way that was skillful and that consistently positioned her as the person who most understood what my father needed. I noticed that after she moved in, my father and I talked on the phone slightly less frequently than before, and that when I visited the house, there was a quality of Claudia's management of the visit that I found slightly effortful, the kind of effort a person makes when they are trying to make sure a conversation does not go in a direction they have not prepared for. I noticed these things. I did not name them. I told myself I was being ungenerous. My father died in November of cardiac failure. He had been in declining health for a year, but the end was faster than the doctors had suggested it might be. Claudia was with him at the hospital. I arrived 20 minutes after he died. I held his hand, and I sat in the room for a while with the specific quality of someone who has just missed the thing they most needed to be present for, and who is trying to understand what it means that they have missed it. The will was read 3 weeks later. $3,000 and personal effects. The note in my phone from Ruth about the ex-husband had been sitting in the Notes app for 3 weeks, and on the night after the will reading, I opened it and looked at it for a long time. I want to tell you what it was like to read the will the first time. I had driven to Milford for the reading, and I was sitting at the kitchen table where I had sat hundreds of times before, and Claudia handed me the document with the specific posture of a person who has prepared for a conversation they expect to go the way they have arranged for it to go. I read it once quickly. I read it again more slowly. The second time I read the paragraph about Nora, I read it a third time because I wanted to be certain I had understood it correctly. $3,000 in personal effects, and I hope she finds peace. I looked up from the document at Claudia, and she was watching me with the expression of someone who has calculated the response they expect and who is waiting to see if the calculation was correct. I said thank you. I put the document on the table. I stood up, and I said I have to drive home. She said, I hope you understand. I said I understand what the document says. I drove home. In my apartment, I sat at my kitchen table for a long time with my phone in my hand, not doing anything in particular. And then I opened my Notes app and I found the entry from the reception, the note about Ruth and the ex-husband looking for Claudia. And I read it and I thought about what questions it was asking. I did not go to sleep early. I made tea and I got out my legal pad and I wrote down everything I knew. Then I started looking for what the records would say about the things I had written. I want to be specific about what I did next because I think the sequence matters and because I think anyone watching who has a similar intuition should know that the steps I took were not complicated and that most of them could be done from a kitchen table in about an hour. I searched Ohio marriage records. The state of Ohio maintains an index of marriage records that is publicly accessible through the Ohio Department of Health and through the county probate courts where the marriages were recorded. I did not have to pay anyone or hire anyone to do this initial search. I searched for Claudia's name in the records for the counties in southern Ohio where she had said she grew up and where she had said she had lived in her first marriage. I found a marriage record. She had been married before, as she had told us. The record showed she had married a man named Glenn Harwick in Clermont County in 2008. I wrote down Glenn Harwick. I wrote down 2008. I wrote down Clermont County. Then I searched for a divorce. In Ohio, divorces are handled through the Court of Common Pleas, and the records are publicly accessible. I searched the Clermont County Court of Common Pleas case search for any domestic relations case involving Claudia's name or Glenn Harwick. I searched her maiden name. I searched her name as it appeared in the marriage record. I searched variations. I found nothing. No divorce filing. No dissolution proceeding. No legal separation. Nothing. I searched neighboring counties in the same region because people sometimes file for divorce in a county where they have moved rather than where they married. Nothing. I searched Hamilton County where Cincinnati is. Nothing. I searched the records for 3 more counties, working outward from Clermont. Nothing in any of them. I took the note from my phone and I transferred it to the yellow legal pad I keep next to my laptop for exactly this kind of thinking. I wrote, Claudia married Glenn Harwick, Clermont County, 2008. No divorce on record in any Ohio county I can find. Claudia married Leonard, my father, in Hamilton County, 2021. If no divorce from Glenn, marriage to father may be void. I want to tell you about the specific quality of the Sunday afternoon when I found the absence. I had the marriage record in one tab and the court search portal in another, and I was methodically typing variations of Claudia's name and Glenn Harwick's name into the search fields, and clicking search and reading the results and finding nothing, and typing the next variation and clicking again. This sounds tedious, and it was not. It was the specific alertness of a person who is looking for something that may be there or may not be there, and who needs to know which one is true before they can know what to do next. By the end of the hour, I had searched 11 counties and found the same nothing in each of them. I sat with the legal pad and I looked at what I had written. Clermont County marriage record, 2008, Claudia and Glenn Harwick. No dissolution in any county searched. Hamilton County marriage record, 2021, Claudia and Leonard, my father. I drew a line between the 2 marriage records and I wrote in the space between them, no legal end to the first one. I looked at that line for a long time. What it meant was not complicated, but what I needed to do about it required someone who knew exactly what it meant under Ohio law and exactly what could be done with it. I looked up Patricia Cho's number, found it in the referral from my colleague, and wrote it on the legal pad under the line I had drawn. I called her in the morning. I sat with that sentence for a long time. In Ohio, a bigamous marriage is void, not voidable. Void. Under Ohio Revised Code Section 3105.31, a marriage is void if either party had a prior undissolved marriage at the time of the ceremony. A void marriage has no legal standing and the purported spouse has no spousal rights under any Ohio statute, including the spousal inheritance rights that Claudia would otherwise have under the will. If the marriage was void, Claudia was not my father's legal spouse. If Claudia was not his legal spouse, the will she had almost certainly had a significant role in preparing might be challengeable on other grounds as well. I called Patricia Cho. The next, I want to say something about what Ohio Revised Code Section 3105.31 says and why it matters, because I think most people do not know this rule exists in the form it exists. In Ohio, a marriage is void, not voidable, but void, if either party had a prior marriage that had not been legally dissolved at the time of the ceremony. Void means the marriage has no legal standing from its inception. It is not a marriage that can be ratified by later conduct. It is not a marriage that a good faith belief can correct. It is not a marriage. The relevant question is not what the parties believed about their legal status. The relevant question is what the records say about their legal status. The records say what they say. A county marriage index showing a prior marriage and a comprehensive court search showing no dissolution of that marriage is the entire evidence the statute requires. Patricia said this to me in our first meeting, and she said it in the specific way of someone who wants the person she is advising to understand the legal structure clearly rather than hoping for an outcome. She said the statute is clear. The question is whether the record is clear. She said the record in your case is clear. She said we are going to file. What I want you to understand, if you are watching and you have any reason to question the validity of a marriage that produced an inheritance you were excluded from, is that the marriage records and the divorce and dissolution records in Ohio are publicly accessible through the county probate courts and the county courts of common pleas. A county index search takes a few minutes. A court case search takes a few minutes. The records are there. They say what they say. You can look that morning. Patricia had been practicing family and estate law in the Cincinnati area for 19 years. She had been referred to me by a colleague whose divorce she had handled with what the colleague described as clear eyes and no wasted motion. When I explained what I had found, she said, "Send me everything you have and give me 48 hours. 2 days later, she called me back and said, "I have confirmed the absence of a divorce record in every Ohio county." She said she had also expanded the search to Indiana and Kentucky, the adjacent states, in case Claudia had filed cross-border. Nothing in Indiana. Nothing in Kentucky. She said I also ran Glenn Harwick's name independently and found no record of him filing for divorce from any person with Claudia's name or known aliases. She said the marriage to your father appears to have been contracted while Claudia was still legally married to Glenn Harwick. She said under Ohio Revised Code 3105.31, this makes the second marriage void and I am going to file to have it declared as such. Patricia filed a complaint in Hamilton County Probate Court to have the marriage declared void ab initio and to have the estate administered under the rules that would apply in the absence of a valid surviving spouse. She submitted Claudia's marriage certificate to Glenn Harwick. She submitted her marriage certificate to my father. She submitted a certified search of Ohio divorce and dissolution records across all 88 counties showing no dissolution of the Harwick marriage. She submitted the searches for Indiana and Kentucky. She submitted a sworn statement from a records researcher she had engaged who had conducted the comprehensive search using the state-level indexes and found nothing. She submitted Glenn Harwick's current address, which her investigator had located in Clermont County, a fact that was not directly relevant to the legal argument, but that was relevant to establishing that Glenn Harwick was alive and that the Harwick marriage had therefore not ended by death. Claudia's attorney filed a response arguing that the marriage to Glenn Harwick had been dissolved through a process that Claudia had believed to be legally valid and that any technical deficiency in the dissolution was an innocent error, rather than an intentional circumvention of the law. The response did not produce a dissolution document, it did not produce a court order, it did not produce any record from any court showing that the marriage to Glenn Harwick had been legally ended. It said Claudia believed it had ended and that she had proceeded in good faith. Patricia's reply was 7 pages and it addressed the good faith argument directly. She said that the Ohio statute on void marriages does not have a good faith exception. She said the marriage is void or it is not, and whether Claudia believes she was free to marry is legally irrelevant to whether she was legally free to marry. She said the record shows she was not. She said the record in this case is not ambiguous. The Harwick marriage was contracted in 2008. The comprehensive search of Ohio, Indiana, and Kentucky records shows no legal dissolution of that marriage. The marriage to Leonard, therefore, occurred while Claudia was still legally married to Glenn Harwick, and it is void under Ohio law regardless of what Claudia believed. The hearing was on a Tuesday morning in the Hamilton County Probate Court. The judge was a probate judge named Victor Reyes, who had been on the bench for 14 years and who had the specific quality of a judge who has spent those years reading the Ohio statutes carefully enough to know what they say without needing to be told. He asked Claudia's attorney one question. Do you have any documentation showing the legal dissolution of the marriage to Glenn Harwick? The attorney said Claudia believed the matter had been handled. Judge Reyes said, I am asking for documentation. The attorney said there was none available at this time. Judge Reyes made a note. He ruled from the bench. He found that the comprehensive search of the relevant records produced no evidence of a legal dissolution of the prior marriage. He found that under Ohio Revised Code 3105.31, the marriage to Leonard was therefore void. He found that Claudia had no standing as a surviving spouse in the estate proceedings. He referred the matter to the county prosecutor. I want to say something about what the phrase void marriage actually means in practice, because I did not fully understand it when Patricia used it, and I think it is worth explaining. When a marriage is void, it means it was never legally a marriage. Not that it became invalid. Not that it can be ended. Not that it can be ended. It means it did not exist as a legal matter from the moment of the ceremony. A void marriage has no legal effects. The parties to it are not spouses in the eyes of the law. They have no spousal rights and no spousal obligations and no inheritance rights that flow from the marital relationship. Any will that was prepared on the assumption that the void marriage created a legal spouse was prepared on a false assumption. This is different from a voidable marriage, which is a marriage that is valid until a court declares it invalid and which requires an affirmative legal step to undo. A void marriage requires only a declaration from a court confirming that it was void from the start. The declaration is not making it void. The declaration is saying what it already was. Judge Reyes was not deciding that the marriage was invalid. He was confirming that it had never been valid. The records said what they said and the statute said what it said, and the declaration followed from the combination. This is why the absence of a dissolution record was the entire case at the first level, not the presence of wrongdoing. Not the presence of intent, the absence of a dissolution record in any of the courts that would have filed it. Absence of a record is itself a record. It says clearly what did not happen. What did not happen was the end of the first marriage. The first marriage that did not end made the second marriage void. The second marriage that was void meant Claudia was not my father's legal spouse. The chain followed from the absence. The absence was in the public records. The public records were there. The estate was then administered as though my father had died without a surviving spouse, which under Ohio law and under the terms of a will that had been prepared under the assumption that the spouse had valid spousal standing, required a full review of the estate plan and its validity. Patricia filed a separate action challenging the will on grounds that it had been prepared under the influence of a person who had concealed her legal status and who had therefore obtained my father's testamentary decisions under circumstances that compromised their validity. That process took an additional 4 months and involved its own set of documentation. At the conclusion of it, I received a distribution from my father's estate that reflected what the legal record said he had intended for his daughter in the absence of the influence that had been shaping his decisions in the last 2 years of his life. I have been thinking about the will challenge and what it required to establish. Patricia said at the start that voiding the marriage was the foundation and that the will challenge was the harder part because voiding a marriage requires only the records and the statute, while voiding a will requires establishing that the person who made it was not making it freely and independently. This is a harder standard to meet from documentary evidence alone because it is partly about a state of mind that existed at a specific moment and that the person whose mind it was can no longer describe. She said we would need to build the picture from the things that could be documented. We documented the timeline of the relationship, the speed from meeting to marriage to will preparation. We documented the attorney and his process and the presence of Claudia in the preparation meeting. We documented the changes in my father's household management and the changes in his access to his own documents. We documented the specific facts about the financial accounts and who had been managing them in the last 18 months. Each of these things individually was not conclusive. Together, they formed a picture that Patricia said a judge who does this work would recognize. She was right. The judge who heard the will challenge was a different judge from Victor Reyes who had ruled on the void marriage, and she had been on the probate bench for 11 years and had seen enough pictures of this kind to understand what she was looking at. She asked questions about the preparation process and about the financial management and about the timeline. And after 4 months of proceedings, she ruled in a written opinion that the will did not reflect my father's independent judgment. The maintenance log entry was the last paragraph of her ruling, and she quoted it directly. She said it was not dispositive on its own, but that in combination with everything else, it was the clearest statement available of what my father had intended when he was not being managed. He spoke with Nora about long-term plans for the house. She is the one who should have it when the time comes. He wrote that because he believed it. He wrote it 4 months before he died. The judge believed him. I want to be careful about how I describe what my father intended because I am not certain about all of it, and I do not want to say more than I know. I know that before Claudia, he had told me on more than one occasion that what he had built was meant to be passed on to family. I know that the $3,000 bequest stood in contrast to the way he had spoken about those intentions in the years before he met her. I know that the will was prepared less than a year before he died, which was after the marriage, and that the attorney who prepared it had had a single meeting with my father during which Claudia was present for part of the time. I know what the revised estate distribution showed. I am going to hold the rest of what I know in the place where things that require more certainty than I currently have are held. I want to tell you about the specific quality of having a case that builds over 6 months while you are also grieving. The legal process and the grief are not separate tracks. They are the same experience, experienced through 2 different registers simultaneously, and the 2 registers do not cooperate with each other in useful ways. The legal process requires attention and precision, and the retrieval of specific facts on a specific schedule. The grief requires the permission to not be attentive and precise, to sit with the specific quality of a loss that does not resolve on a schedule and that cannot be filed with the court. I managed both of them by keeping them on different days when possible and by not expecting either to wait for the other when it was not. On the days when Patricia needed information from me, I organized what she needed and sent it. On the days when I was sitting with the specific grief of losing a father who had been one of the most reliable anchors in my life, I gave that the room it needed, and I did not try to also manage the legal situation on the same day. Some days I had no choice, and I managed both. Most days I had some choice, and I tried to use it. I am telling you this because I think people who find themselves in similar situations should know that doing both things at once for several months is hard in a specific way, and that the hardness does not mean you are doing it wrong. It means you are a person dealing with two large things at once, and that is genuinely hard. And it is also manageable if you find the right support and keep the right records and call the attorney when the attorney needs to be called, and allow yourself to grieve when that is what is needed. Both things are real. Both things require tending. You can tend both. I did. Claudia has not contacted me since the second ruling. I do not know where she is, and I have not tried to find out. I hold what she did with the specific patience of someone who has decided that she does not currently have access to a conversation that would help anything and who is not going to pursue one that would not. There may come a time when I feel differently. I am not in that time now. I want to say something before I go. There is something I want to say about Ruth. I have mentioned her briefly as the neighbor who made the comment at the reception, and I want to say more because she deserves more than a brief mention. Ruth had known my father for 20 years. She had been his neighbor since before he moved to Milford, and they had been the specific kind of neighbors that people become over 2 decades of proximity, not close friends exactly, but genuinely knowing each other, aware of each other's patterns and visitors, and the specific ordinary life that each of them was living. She had watched Claudia arrive. She had watched the changes in my father's household patterns. She had not said anything because it was not her place, and because my father had seemed, to her observation, content. She mentioned the ex-husband at the reception because she had been sitting with it for a few weeks, and because she thought I should know, and because the reception was the first time she had seen me since before my father's health had declined, and it was the moment available to her. She did not know what it meant legally. She knew that a man had come looking for Claudia, and that he had said he was her ex-husband, and that the combination of those facts seemed like something I should know. She was right that it was something I should know. She told me at a reception in a lowered voice the way people tell things at receptions when they believe something needs to be said, and a reception is the moment available. I wrote it down. She told me, and I wrote it down, and that is how this story started. A neighbor who had known him for 20 years deciding that a daughter should know a thing. Thank you, Ruth. I have also thought about what would have happened if Ruth had not said anything. If she had held the observation the way people sometimes hold observations that are potentially significant, but that feel like not their place to share, I would not have had the thread to pull. The records were there, but I would not have known to look. The marriage index and the absence of a dissolution would have been there, unchanged, while Claudia administered an estate she had no legal right to. The records do not find you, you find them. And you find them because someone tells you to look. Ruth told me to look without knowing she was telling me to look. A comment at a reception. That is where this started. Not about Claudia, and not about the prosecutor's referral, and not about the will challenge. About Ruth, my father's neighbor of 20 years who mentioned at a funeral reception that a man had been at the house looking for Claudia. She mentioned it in the way people mention things that seem potentially relevant, but that they cannot fully assess themselves. She was not making a legal argument. She was not presenting evidence. She was a neighbor who knew something and mentioned it to the person she thought should know. I wrote it in my notes app because I write things down when they seem like they might matter later. I searched the marriage records from my kitchen table because I knew the records were public, and I had Ruth's note and a legal pad and a few hours on a Sunday afternoon. I found the Harwick marriage in a county index because it was there and because I searched for it. I found nothing in the divorce records because there was nothing to find. That is the whole chain of events that started this. A neighbor who mentioned something. A person who wrote it down. A public records search that took about an hour. Thank you for staying until the end. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a woman whose landlord had been collecting rent on a property that county tax records showed he did not own, and what the deed transfer timestamps revealed, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if someone receives a significant inheritance at speed from a relationship that moved faster than seemed natural, the marriage records and the divorce records are public. Both of them. They will say what they say. I want to tell you about Milford, Ohio, and about the specific quality of my father's house there, because the house is a character in this story, in the way that places become characters when people have lived in them long enough to leave their habits behind. Milford is a small city east of Cincinnati along the Little Miami River, in the particular part of southern Ohio that has the texture of places where people have been living and working for several generations without substantial interruption. The house my father bought 14 years before he died was a 3-bedroom craftsman on a street with mature oak trees that produced an enormous amount of leaves in October, and that my father raked every year with the specific satisfaction of someone who has accepted that this is a seasonal task and who has made it part of the rhythm of the year rather than a burden to be avoided. The house reflected my father in ways that are particular to spaces that have been inhabited by the same careful person for a long time. The bookshelves in the front room were organized by subject and within subject by publication date. The tools in the garage were hung on pegboards with outlines drawn in marker so that the tool could be returned to its exact position. The garden was planted in a grid that he had mapped on paper and updated every spring to track which areas had been used for which crops and what the rotation should be the following year. He kept a maintenance log for the house that went back to the year he bought it, dated entries noting what work had been done and when and by whom, so that he always knew the age of every system in the house and could anticipate what would need attention and when. He was the kind of person who had internalized over the course of an engineering career that systems require maintenance on a schedule, and that understanding the schedule of a thing means you are rarely surprised by it. I want to tell you about what my father's house looked like after Claudia moved in because it is relevant in ways that are not just emotional. The house was the same house, the structure was the same, but the specific order of it changed. Not I want to describe my father more specifically than I have, because I think the specific kind of person he was is relevant to understanding why what was done to him was possible, and why the record he kept was what it was. He was a structural engineer for 38 years, and the central characteristic of his professional formation was a deep and habitual trust in observable evidence. He did not theorize about what a structure was doing under load. He measured it. He did not assume a material had the properties it was supposed to have. He tested it, or he read the test records from the manufacturer. He applied this approach to everything outside of work as well, not as a personality quirk, but as a philosophy that he had developed over the course of a career in which being wrong had real consequences. He trusted what could be verified. He wrote down what he could verify so that it remained verifiable afterward. He kept logs. He dated entries, he initialed them. He understood that memory is unreliable and that the record is not. This was also, in ways he would not have anticipated, a vulnerability. A person who trusts observable evidence and who has spent 11 years living alone and working in his garden and restoring historical documents at the local library is a person who has perhaps not maintained the level of social alertness that comes from living in a more complex social environment. He trusted Claudia because she presented well and because he applied his usual standard, which was to observe the evidence available, and the evidence she made available was warm and capable and reliable. The evidence she kept unavailable was in the county records of a marriage she had described as over. He could not have known to look for what she had not disclosed. He was trusting, and his trust in this case was placed in a person who had made a specific decision not to provide the information that would have changed his decision. What he left behind was a record that said, in his own hand, what he had actually intended. The record he had trusted all his life held what he had actually intended, and the record was there when it was needed. I also want to tell you that he knew I wrote things down too. He had taught me to by the example of watching him do it. He would have found it entirely consistent with who I am that on the night after the will reading I got out a legal pad and wrote down everything I knew. He would have done the same thing. He would have said, "Start with what the record shows." I started there. I found what the record showed. He would have approved of the method. The cleanliness, Claudia kept the house clean, but the organization of it, the system of it, had been overlaid with a different kind of management that was less about knowing where things were and more about controlling who could access what. The bookshelves were rearranged. The maintenance log that my father had kept in a specific binder on the shelf in the kitchen was moved. The documents folder my father had kept in the front room with his financial papers in it, the one I knew about because he had shown it to me once and had told me what was in it, was not in the front room when I looked for it after the will reading. It was eventually located in a filing cabinet in the spare bedroom that Claudia had taken over as her personal space. My father's financial papers were in a cabinet in Claudia's room. I noted this. The attorney who prepared the will had an office in Milford and had been referred to my father through Claudia's social network rather than through any of my father's own long-standing contacts. My father had used a different attorney for his previous will, the one that had been in place before Claudia, and he had not used that attorney for the updated one. The updated will was prepared in a single meeting. The attorney was a person who prepared basic estate documents and whose practice was not specialized in complex estate planning. Patricia described the preparation process, from what the file showed, as streamlined in ways that a more careful practitioner would have questioned, specifically the fact that the meeting was short, that Claudia was present for a significant portion of it, and that there was no independent interview of my father to ensure the document reflected his autonomous wishes rather than the wishes of a person who had significant presence in his life and significant financial interest in the outcome. I want to tell you what it was like to do the initial record search. I have described the result of it, but I want to describe the experience of it because I think it is important for people watching to understand that this was not a professional investigation. I was sitting at my kitchen table on a Sunday afternoon in December with a cup of coffee and my laptop. I had Ruth's note in my phone and the information about Claudia that she had given us in 2 years of knowing her, her maiden name, the county she had grown up in, the approximate year of her prior marriage. I went to the Ohio Marriage Records Index first. I searched Hamilton County where Cincinnati is. Nothing. I searched Clermont County because she had said she grew up in that area. It took me approximately 3 minutes to find the Harwick marriage record, 2008, Clermont County. The record listed her maiden name, Glenn Harwick's name, the date, and the registration number. I sat with the Harwick marriage record open in one browser tab. In another tab, I opened the Clermont County Court of Common Pleas case search portal. This is a free public search available to anyone at the Clermont County website. I typed in Claudia's maiden name. I typed in Glenn Harwick's name. I searched both domestic relations and general civil. I found nothing. I expanded the search to other counties. I searched Hamilton County. I searched Warren County. I searched Brown County and Adams County and Pike County, working through the southern Ohio counties systematically because I was trying to be thorough rather than assuming the absence of a record was definitive after one search. I spent about an hour doing this. By the end of the hour, I had found the Harwick marriage and no dissolution of it in any county I had checked. I wrote this down on my legal pad in clear numbered points because writing things down in clear numbered points is how I process information that matters. My father used to say that the most useful question a person can ask is, what does the record say? He said this in the context of engineering work, the records of a structure, the records of a material, the records of a previous repair. He said you can have a very confident theory about what happened to a building, and you can be entirely wrong about it, and the way you find out you are wrong is to look at what the record says. He said the record is not always complete, and it is not always easy to read, but it is always more reliable than what someone remembers or what someone says. He taught me to trust the record by the specific example of how he trusted the record in everything he did. I was looking at the records of a marriage and a non-divorce and trying to understand what they meant. And what they meant was what they said, and what they said was clear. Patricia Cho's office was in a building near the courthouse in Cincinnati, the kind of building that houses the practices of lawyers who work with the actual mechanisms of the legal system rather than with the corporate or transactional side of it. Smaller offices, waiting rooms with chairs that have been there for many years. A quality of the everyday business of people's real lives being handled with attention and care. She was 52 years old and had been doing this work for 19 years and had the specific bearing of someone who has seen enough of what families do to each other around money and death to have lost any ability to be surprised by it and to have retained, through that loss of surprise, a very clear view of what the relevant statutes say and what they can do. She said to me in our first meeting, I want to lay out what I believe we have and what I believe we can do with it, and then I want you to ask me the questions you have and tell me the things I have not asked about. I said, okay. She laid it out. The questions and additional things took about 40 minutes. When we finished, she said, "This is a clean case at the void marriage level. The challenge will come from the will challenge, which is a separate proceeding and requires a different argument." I said, "I understand." She said, "Let us start with the void marriage because that is the foundation. If the marriage is void, the entire structure of the inheritance changes." I said, "Yes." She said, "Then let us file." There is something I want to tell you about the 4 months between the initial void marriage ruling and the conclusion of the will challenge, because those months had a specific texture that I want to describe. The initial ruling was a clear and relatively rapid proceeding. The will challenge was slower. It required establishing not just that the marriage was void, but that my father's testamentary decisions had been made under circumstances that compromised his autonomous judgment, which is a harder thing to establish from documents alone. Patricia said at the outset that the will challenge would require us to build a picture from circumstantial evidence and from the documentary record of the preparation process, and that the picture would have to be clear enough that a judge could see it without us having to ask the judge to speculate. We spent those 4 months building the picture. We interviewed the attorney who prepared the will and documented what he remembered about the meeting and about Claudia's presence. We documented the time frame of the relationship and the speed of the succession from meeting to marriage to will preparation. We documented the financial structure that Claudia had gradually taken over in the last 18 months of my father's life. We spoke with Ruth and with 2 other neighbors who had known my father for years and who had noticed specific changes in his circumstances and access after Claudia moved in. The document that Patricia called the most important single piece of the will challenge was not a dramatic revelation. It was the maintenance log. My father's maintenance log for the house, the binder that had been in the kitchen until it was moved to Claudia's filing cabinet, contained dated entries that went back 14 years. Among those entries were entries from the last 18 months of his life that reflected his decision-making about the house and his planning for it. The last entry, dated in my father's handwriting, approximately 4 months before he died, said, "Spoke with Nora about long-term plans for the house. She is the one who should have it when the time comes." The entry was dated in my father's handwriting with the specific precision of a person who has kept records all his life. It was not a legal document, it was a maintenance log entry. But it said in my father's own hand, in a document that no one had known to falsify because no one had known it existed or that it would matter what he had intended. Patricia said it was not controlling on its own. She said it was the kind of evidence that, placed alongside everything else, made the picture clear. The will challenge concluded in March. The ruling found that the will had been prepared under circumstances that raised sufficient concerns about the independence of my father's testamentary judgment to warrant setting aside the bequest structure. The estate was distributed under a combination of the prior will, the one that had been in place before Claudia, and the evidence of my father's intentions as documented in the maintenance log and in the testimony of the people who had known him longest. The distribution was not the full resolution of everything I had hoped for. Some of what my father built had been spent or moved in the period between the marriage and his death in ways that were difficult to fully trace or recover. Some of it came back to me, some of it did not. I have made my peace with what was recoverable, and I hold the rest the way I hold all of the things that cannot be fully resolved, with a specific patience that is not resignation, but is also not pretending that the resolution was complete. What I have that I did not have before is the correct record. The record that says the marriage was void. The record that says the will did not reflect my father's independent wishes. The record that has in it my father's own handwriting from 4 months before he died, in the maintenance log he had kept for 14 years, saying Nora is the one who should have it when the time comes. He was a man who trusted the record. He kept a record. When it mattered, the record was there. I also want to say something about what the resolution of the case felt like, and to say it honestly rather than with the specific satisfaction that a story about justice prevailing might seem to call for. The legal outcome was the correct outcome. The record said what it said, and the court confirmed it, and the estate was administered correctly in the end. And in the process, I lost my father and I spent 6 months in legal proceedings that required my sustained attention during the period when I most needed to be grieving. And I watched a person my father had trusted attempt to take what he had built using a legal status she had obtained through concealment. These things are not resolved by a court ruling. The ruling addresses the legal questions. The other things are larger and more permanent, and they live in a different part of my experience. I have my father's house now. I have been in it twice since the estate was settled, and both times I walked through every room and I looked at the bookshelves organized by subject and publication date, and the pegboard in the garage with the outlines for the tools and the maintenance log binder back in its place on the kitchen shelf. I picked up the binder and I leafed through it to the last entries in my father's handwriting, and I found the one from 4 months before he died, and I read it again. Spoke with Nora about long-term plans for the house. She is the one who should have it when the time comes. I stood in his kitchen and I held the binder, and I thought about him writing those sentences at that kitchen table in the specific way he wrote everything, with the date at the top and the initials at the end, trusting the record to hold what he had decided. The record held. I am in the house. I will keep the log. I want to say something about the specific experience of being in the courtroom when Judge Reyes asked Claudia's attorney for documentation of the dissolution of the Harwick marriage. I was sitting at the petitioner's table with Patricia, and I watched Claudia's attorney give the answer that Patricia had told me he was likely to give, which was an answer that explained what Claudia believed rather than producing what the judge had asked for. He said she believed the matter had been handled. The judge asked again, more specifically, whether there was a document. The attorney said there was no document available at this time. The judge made a note. The quality of the note-making, the deliberateness of it, the way the judge looked at what he was writing, and then looked up, and then looked at the document in front of him, and then looked back at what he was writing, told me something about how he was processing what he had just heard. Patricia had told me before the hearing that a judge who has spent years in probate work understands the weight of an absence of documentation. She had said the absence of a dissolution record is not a neutral fact. It is a specific absence with specific implications, and a judge who has done this work knows what those implications are. She was right. The ruling followed from the answer. The ruling followed from the absence. I also want to tell you about the moment I found the Harwick marriage record in the Clermont County Index. I have described the search, but I want to describe the moment of finding it. I was scanning the results of the search, looking for her name, and I saw it, the entry with her maiden name and Glenn Harwick in 2008, and I sat very still for a moment, not because I had not expected it. She had told us she was previously married. The marriage record was not the finding. What I sat still for was the understanding that the finding I was actually looking for was the one in the next search, the absence. The marriage record meant the next search mattered. If there was a marriage and no dissolution, I had something. If there was a marriage and a dissolution, I had nothing. I opened the Clermont County court portal with the specific alertness of a person who has found the first piece of a chain and who knows the next piece will determine whether the chain means anything. I typed in the names. I looked. I found nothing. I typed in variations. I looked. Nothing. I sat with the nothing for a while, and then I typed the nothing on my legal pad and I circled it, and I understood what it meant. I want to tell you about Glenn Harwick. I never met him, and I know very little about him as a person. What I know is that Patricia's investigator located him living in Clermont County, the same county where the marriage had been recorded in 2008. He had not remarried. He had continued his life for 16 years with a marriage certificate in the county records that connected him to a woman who had gone on to marry someone else while still legally married to him. He may not have known. He may have known and decided not to pursue anything. He was not, as it turned out, relevant to the legal proceedings themselves because the Ohio statute does not require the prior spouse's participation in a void marriage determination. His existence was relevant in a single specific way, which was that he was alive, which meant the Harwick marriage had not ended by death, which meant the only way it could have legally ended was through a dissolution proceeding, and the record showed no dissolution proceeding had ever occurred. Glenn Harwick, alive and in Clermont County, was the fact that closed the only other avenue. That is the only thing he was in this story, the fact that closed the remaining avenue. I hope he is well. I have been thinking a great deal in the months since the resolution about what it means that the most important document in the case was a maintenance log. Not a will, not a deed, not a financial statement. A binder that my father had kept in the kitchen of his house for 14 years, recording the maintenance work he had done on his own property. The specific kind of record that a careful person keeps because careful people keep records, not because they expect the records to be needed in court, but because the records are the correct way to manage a thing you are responsible for. He had been recording the maintenance of his house since the day he bought it. He had been recording decisions and conversations and plans in the same log as the practical notes about the furnace filter and the gutter cleaning. He did not know when he wrote the entry about Nora and the long-term plans for the house that the entry would be read by a judge. He knew that he had thought about something and that thinking about things was worth writing down. He trusted the record as a form of thinking clearly. The record held what he had thought clearly, and the record was there when it was needed. That entry is 4 sentences long. It says he spoke with Nora about the long-term plans for the house and that she is the one who should have it when the time comes. 4 sentences in a maintenance log. My father wrote them in the specific way he wrote everything in that log, with his date at the top and his initials at the end, the way he had written hundreds of entries over 14 years. He was not composing a legal document. He was recording a fact about a decision he had made and a conversation he had had, the way he recorded the fact about the water heater being inspected or the oak tree in the backyard being trimmed. He applied the same care to both because he believed that recording things correctly was a habit that should not have exceptions. He had no way of knowing that this particular entry, one of several 114 years of logs, would be the one that mattered. He just wrote it down correctly because he wrote everything down correctly, and because that was who he was.